you can use this software. And it is AI also is getting integrated within the tool, and it's a wonderful tool. So anyone who wants to request for a demo, the links are already here in the chat box. Right now, just if you go click, just mention your name, number, etc. in the form, and our team will contact you for the demo. Okay, coming to the questions. Now, there are a few questions. Surbhi, I'll ask you the question and request if you could sort of answer. Now, first question is it possible to register a trademark application in India if it has been registered and approved in US by parent company?
So yes, if a mark is approved and registered by the parent company in US, it can be registered in India. But then you will have to do the trademark search again. You will have to see if that mark is already being used by somebody else, or if it is falling in the grounds of refusal that we just discussed. If it is within those categories, you cannot register. Otherwise, it is very well open to be registered.
Right. Next is please brief about multi-class application. I think that's a wonderful question. Multi-class application, what is course of action available if registration of the proposed trademark under a multiple class application is opposed in single class?
So there is also a concept of filing multiple classes in one single trademark application. That is also done by people, which is not advisable by me individually, I would say, because every class is, like I mentioned, is judged independently. If you have filed different applications, each application will be judged by the examiner. There can be a scenario one is registered and one is not. But if you have received objection in one and not in the others, you will have to convince examiner. And there is also one more ground available to you. You can also convince examiner saying that, see, I have already obtained registration in other classes. The examiner will note down your registration number. It will be also considered, and more often your marks are also associated. It is also written by the examiner in the final order that your mark will be associated with this mark because that mark is registered in this particular class. You will also get registration in the other class. So that's how multiple classes functions.
Yeah, so what you're saying is it's advisable to go for single classes because even if
Yes,
one
yes,
gets rejected, the other may be approved, and even the associated classes may get some good value in the other classes registration. So
yes,
that
yes.
is, but the second part of the question was, what if in a multiple class application, you file a multiple class, but the opposition comes from a single class, some other party. So what happens then?
So in that particular class only, you will have to go for that opposition suit. For rest of the classes, you have registration. So that's not a concern. Maybe that opposition is filed for in a particular class because that person is selling goods or providing services in that particular class only. So for rest of the classes, you are well to go ahead and use that mark.
So probably in case the other party wins in a single class, maybe the multiple class you will not get registration in that class which was opposed,
Yes,
and if
yes,
the other party wins it, but in other classes you will win it, right? Isn't it?
yes, yes.
You
That's right. Yeah,
Okay,
that's
next
right.
is which is the most secure trademark class type? It's a I'm laughing at this question. One, it's a cute question. Most secure, I mean, all 45 are equally secure or equally insecure. Should first priority be given to the trademark the name, device, or logo?
I
I think
think,
let me answer this
yeah.
question. So I think there is nothing called insecure or insecure. Yeah, I think what is important is relevant or non-relevant. So if you are manufacturing oils, you can't say no class. The class of pharma is better. So let me, that is more secure. No, nothing like that. Each class describes the types of products from class 1 to 34 and services from 35 to 45, and you have to file where you fall in genuinely, because you have to give proof of usage also. And nowadays with the trademark hearings at almost at all the in all the cases, trademark objections come, you have to give examination reports come, you have to give the replies, and hearings also happen in most of the cases, etc. So something which is more relevant where you can prove is what is important rather than the class rather than which is more secure. And second is name, device, or logo. I would say, I mean, logo. I mean, all three are registrable. But yes, if you have a unique word per se, and you can go with both or all also. So word mark and logo also can be registered separately. So if you'd like to add anything.
Yeah, so I'll take up the second question first, word, device, or logo. So if you take proprietary on the word, let's say eMinds legal is the word mark that we have registered into. We can use it in different font. We can use it upside down. We can change the font size also. So that can be done. It is the purpose of getting the mark registered as a word mark. When you register it as a device mark, you cannot change that mark. It is actually the logo which you'll affix wherever you want to use that. So it also depends on the person to person, but I would advise that it is registered in both cases. If you have a specific logo attached with the word mark, it should be registered in the form of a device mark. Otherwise, the word mark will also go. That's also possible. As far as the first question is concerned, which was that which class is
Right.
secured, you
Now,
have rightly mentioned. I think, yeah. So as far as the secure classes are concerned, there is no such secure class. You have to decide your business. The business that you are dealing into will decide what is the class that you want to go ahead with. Be that a pharma or manufacturing unit for clothing industry, apparel industry. If you're dealing in apparel industry, you won't go in the oil industry. So that depends on your business that you are into. First, decide your business and the class will go on. You can get it registered in that particular class.
yeah, and one can go in multiple classes also. Sometimes
Yes.
multiple classes make sense for one particular business, and that's the job that eMinds Legal does for its clients when the logos or the word marks come. So first thing is to do the search. Second is to advise on which classes, and then the assignment starts. Okay.
Yeah.
So, there'll be a few more questions. So, can colors be trademarked? You had a slide on purple. You mentioned about Cadbury's purple color, or I can also draw parallel between, the Domino's, the blue and white, the colors indicate the brand very quickly, or sometimes the orange of orange of Swiggy, or the red of Zomato, or the pink and blue. I remember of Vishal Mega Mart, the carry bags that we used to have. So, can colors be trademarked as such?
Yes, they can be. So just like I mentioned, if you register your mark in a particular color combination, you will have the right to use that mark only in that particular color combination. Like Vishal Mega Mart, pink and blue. So they can only use their mark in that pink and blue color combination. They have their right. Nobody else can use their mark in the same color combination. But like I mentioned, if they use it in black and white, you have rights over all kind of color combinations, not
So
just
that is
pink and
fine. Surbhi, that is understood. But what my question
blue. Yeah.
again, the question on top of it is, for example, the if you just say the pink and sky blue of the Vishal Megamart carry bag. Now, okay, the Vishal Megamart logo can be in black and white and say all colors are protected, but that unique color combination, the color itself, tells you that this is Vishal Megamart, for example. So can somebody trademark the colors itself? The pink and blue. Can other people print the pink and blue carry bags in the same fashion? Forget the logo and the mark.
Yeah,
Or
color,
the
if they're
purple,
using it.
or the purple wrapper of Cadbury, for example. Can Five Star also use the same purple wrapper just like Cadbury and mention Five Star on it?
Yes, Five-Star can do that. The reason why Purple Cadbury case was in picture and why their mark was registered was in the services they had mentioned they want to use it predominantly. So that was subject. That term predominant was not mentioned clearly that how much is the color that you're using. 60% of their mark is in purple color, 80% or majority part of it. So you have to be very clear and concise and you can use that mark. Similarly, if you're getting mark registered in purple and pink, somebody else can use it in the same fashion. So not that color combination is a proprietary you have, but color combination along with the logo is what you have your rights on.
Sure. Okay, there's another question called restoration of trademark. It was mentioned in the PPT as 1 year from the date of expiry. Is it after 1 year period provided to submit renewal application, or after extra 6 months grace period with additional charges allowed to submit application? So maybe you could touch base on the
So
renewal.
restoration, yeah. So restoration is done once your mark is removed. Your mark is removed after that. First, that 1 year expiry, one year period is there when you have to renew your mark with simple renewal fee. After that 1 year expiry, you have another 6 months to give that surcharge fee and get your mark renewed. After the expiry of 1 year and 6 months, your mark is removed. Once that mark is removed, is when restoration comes into picture. So restoration is after all your remedies are exhausted, and that can be done only when your intentions are clear. Yeah.
Sure. Okay, next question is how much time does it take, from filing to registration normally nowadays?
So nowadays, trademark registration process, though the registry has been trying to wrap it up really fast, but what we have seen is if in case your mark is very unique and it is a coined work, there is no similar mark registered in the trademark registry already, no pending application is there, it can be registered within 6 months, because that's when the examiner scrutinizes your application and responds with the examination report. However, if there is a mark already in place, you fall under the other categories of refusal, you'll have an examination report and it might go on to 3 years also. There are instances when even 2 or 3 times an examination report is issued, you'll have to give replies, and for hearings, there is a considerable amount of time which is taken by the registry. So 6 months to three
Understand.
years, I would say.
Is there any percentage you would like to sort of pick, in terms of success percentage, filing versus registration? Surbhi, in your experience of registering hundreds of these marks, means not to indicate, means generally in your experience, what is the success percentage of registration of marks at a very, very high level?
Would, yeah, I
Is
would
it like
say
80%, 90%,
yeah,
50%?
more than 90%, because when we get a request from the client, it's when we start our work, we do research and the class search very proper, that at the end we actually know what is the objection that is going to come from the examiner. So we analyze that, sit with the clients. If it is a proposed to be used mark, we even suggest that you change your mark or you think for something else which can be registered easily. So after all this homework, we go ahead and file application. So the success rate is more than 90%, I would
Yeah,
say.
so I think the key is that if the homework is done well and if the preps are done well in advance in terms of trademark searches and the classes and the advices and preempting the objections, then I think the success rate could be higher. Right.
Yeah, that's right.
Would you like to throw a light on well-known marks, Surbhi? What are
Yeah.
well-known marks?
So well-known marks are which are already in. For example, you mentioned dominoes. So marks which are there in the market for good number of years, so let's say 10 years, 20 years, and they have actually monopoly on that industry. Now, when we see pizzas, there are 2, 3 names which should come to our mind: Domino's, Rapino pizzas. So even if there are new pizzas, startups coming up in place, you will always prefer these marks over the marks which are there. So these are well-known marks. Even if you have Domino's in, you want to have that domino mark registered in other class, you cannot do that because that mark already has a well-known established market in the pizza industry. So that's what well-known marks are.
Yeah, but is there any criteria or threshold for what is well-known? When you say established means what is established? Is there any criteria defined in the act or rules?
No such criteria defined in the act. It depends on how the mark is being used in that particular geographical area, and how long since that mark is being used in that place. So
Understand. These are facts and circumstances of each case, which maybe the
yeah,
trademark registry will take into account
yes,
while
yes,
giving those things. Yeah. All
yeah,
right.
that's
For example, on a lighter note, we have, of course, Reliance would be a well-known mark in India. Who doesn't know Reliance? But of course, in the old Gurgaon, I saw a shop called Reliance Tailors. So, those kind of things,
happening.
but he may not have gone for a trademark registration, so that's fine. So, okay.
Yeah.
So, since you mentioned about startups, so are there any special benefits for startup companies for trademark registration?
Yes, so trademark registry do provide a lot of benefits. One of those benefits is when you file the trademark application, for every company, it is 9,000 per application, but for startups, they have a reduced fee of 4,500. So that fee is also reduced, and then after the registration also, this is for everybody, I would say. For trademark, grievance portal is also there, where grievances are solved. Even before going to the court, people very often say that cost is associated with the trademark filing, and if your mark is infringed, there is a lot of cost. But now grievance portal is there, you can approach to that grievance portal, you can file your complaints database, sending an email, and trademark registry will take it up. So this is, though, on another note, this is applicable for all the companies, but for startups, that time period, that fee structure is reduced for
4,500, and I
MSMEs.
think not only startups, even MSMEs,
Individuals,
also
yeah,
individual
MSMEs
MSMEs,
and individuals.
yeah,
Yeah.
same reduced fee. All right. Okay. So I think we have almost reached towards the end of the webinar. I think one last question I'll take. Which trademark type is most preferable, device or word? Although there's no straight or easy answer to this, but yes, any pick on that.
Again, so word mark, if you just want a particular word to be proprietary on, no specific elements, added elements to it, like Apple, APPLE is the only, these letters are the only letters that you want trademark on, go for word mark. But if you want added elements to it, slightly a font size is changed, or sorry, font style is changed, certain added elements like a photo is there, a symbol is there, then of course a device mark would be required.
Understand. Okay, before we end, let me just launch another poll. You saw a video about COMPLINITY and you got a brief also. It's India's leading compliance software. So anyone would like to have a demo of the COMPLINITY compliance software, please indicate yes or no. And also, would you like to be a future speaker in these webinars? Please indicate. In that case, we will sort of invite you to be one of the speakers. So very quickly, if you could indicate your preferences here. And any last word, Surbhi, on the topic? Any closing remarks?
Yeah, so while discussing, there was one case that was in my mind. I just missed discussing that. So trademarks today are important to be registered, but at the same time, while using your mark, it is very important you do homework. You see if there's any other mark which is in use or not. Like recently, Delhi High Court had issued an interim order against the Oscar-winning A.R. Rahman and a production house, which was not a small amount. That was somewhere around 2 CR, because they had used a song in their Tamil movie, which was not just inspired but totally identical to Shiv Stuti, which was produced by Junior Dagger brothers. So that's why in today's world, trademark is such an important issue that first you protect your mark, and second, while using any mark, you should be aware if that mark is already in place or not, so that you're not infringing any others. So yeah, that's it.
Okay, on that note, Surbhi, thank you very much for a wonderful session. I think this was very enlightening. I learned a few things as well, and I'm sure the audience also would have enjoyed the session. So thank you, Surbhi, and thank you, audience, for a patient hearing. And thank you, everyone. Thank you, COMPLINITY team,
Thank
for
you.
organizing and support. Thank you. Bye.
Thank you, Sumit, for having me as a speaker. Yeah, thank you.
Bye.
Thank you, Compliment.
Welcome to COMPLINITY Technologies. COMPLINITY is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. COMPLINITY is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000+ laws and 24,000+ compliances, all in an integrated platform that is easy to use with automated alerts and risk management capabilities, is why compliance managers, general counsels and chief financial officers choose COMPLINITY every time. Join the most innovative and prestigious brands that use COMPLINITY. Automating your compliance management. Request a demo at complinity.com.